Okay, everyone, we're live. Thank you for joining us. I have my favorite attorney guest here, Zach Morgan. How's it going, Zach? It's been so long.
It has. It feels like it's been a long time. It's been a what about? Well, I guess we did it a little over a week ago, right at the beginning of the Thanksgiving break. So I hope everybody had a refreshing break and able to get fired up for the home stretch before we end 22.
So I'll tell you what, before we get into it, I'm just going to do a shameless plug asking people to subscribe to the channel. Asking people to subscribe is something I never do. I've always felt it was very cheesy. But Zach, I'll tell you what, the 1 week I did it was the week leading up to 100,000
Mm-hmm.
subscribers, right? The 1 week I got 10,000 subscribers, and I was like, maybe I'm just stupid not to ask people to subscribe. So anyhow, just wanted to get that out of the way. So Zach, I've been keeping a close eye here on Twitter. I've been keeping a close eye on the Underground Bunker blog. Aside from the morning report about the jury substitution, there hasn't been any new updates. What do you tell us what the updates are, and what do you make of them?
So, and I think this is probably not a surprise to anybody. In fact, it may have happened to some of your viewers' families. I hope not. But two of the jurors gave the court notice over the weekend that they were symptomatic and COVID positive. So of course they can't appear in public um, until they're healthy. And then another one had indicated that they had also tested positive, but for strep throat and were on some sort of antibiotic regimen and had asked to be excused for 24 hours until fever free, not symptomatic, the whole thing. And so the judge brought all the attorneys in, also asked for Mr. Masterson to be present. Sorry, I'm hoping my emails will quit being in here in a minute. That Mr. Masterson be present and said, here's what I think I'm going to do. I'm going to replace the two COVID positive jurors with the alternate, and then I'm going to with two alternates, and then I'm going to excuse the juror for today, the alternate for today, who's got strep throat, and then if we need them, we can theoretically adjourn until tomorrow until they're better. And of course, Mr. Cohen, Danny Masterson's attorney, raised all kinds of objections and said no. Um, Sort of objected. I'm going to say prima facie. It's a Latin phrase meaning on its face. Sort of objected for the sake of objecting, but didn't appear to make any type of legal argument as to why they shouldn't be replaced. Cohen actually spent a significant period of time arguing that he wanted the jury to have to explain why they wanted Thanksgiving week off. They had apparently over the break gone back and reviewed some transcript from the jury selection process and said only one person said they couldn't work through Thanksgiving week. And now you're saying a bunch of them did, and that person was on the jury as a whole thing. And the judge said, more than one person has communicated with my office that they can't be here. That's good enough for me. And then Tony Ortega's notes indicated that she overruled a motion for mistrial. And I don't know if that was an oral motion, meaning just made on the spot, judge, this is grounds for mistrial, or whether a pleading had been filed, but had in some capacity moved for a mistrial as well. It appears that the jury was, I believe, a 6-5 gender split male female, and now it's 6-6. Two women jurors were replaced because they were COVID positive. The alternates were one man and one woman, so now it's a 6-6 male female. And based on the lunch notes that Tony Ortega put out and in the short video that he posted, it looks like this jury is the current makeup of the jury is progressing maybe a little more quickly than they had finished last week. But I think it's important to note that the judge, and I believe rightfully so, and I mentioned this to you earlier before we went on the air, the judge said you have to start deliberating again. We can't throw a new juror or new jurors into this mess when everybody's voted and you're almost done. You have to start over again because really this is a brand new jury. Those alternates were there to hear testimony, but this particular makeup of the jury is a new makeup.
Let me ask you a question here. Like you said, Rob Cohen, the defense attorney, was making a very big deal over the fact that he didn't think there was good reason for the jury to take off last Monday and Tuesday. Last Monday and Tuesday wasn't Thanksgiving. And he didn't think any of the jurors that were seated at that time had expressed any hardship. Would it actually be grounds for a mistrial if Judge Almeida had given the whole jury off, the jury the whole week off with no particular such request coming from the jury? Why was he harping on that so much?
he's trying to make a record to give every possible grounds for an appellate review, or not appellate review. They'll review it as a matter of course on his appeal, but trying to make the record, trying to raise every grounds for reversal if this comes back with an adverse outcome by way of conviction to Danny Masterson, at least adverse from his perspective. And so I don't know that it makes much difference. I mean, theoretically, to me, there's no difference. You let the jury off for a week for Thanksgiving. They were going to lose Thursday and Friday anyway, probably Wednesday. There's no different than if the snow was so bad in the Northeast, the jurors couldn't get to the courthouse because of the snow. So you cancel and suspend jury deliberations until they can safely get to the courthouse. To me, there's no difference. They were given the admonition, don't talk to anybody, don't talk about this case, don't do any independent research. I don't know that it makes a difference either way.
Okay, I was about to say that, the jury before the break had expressed that they were essentially deadlocked. And I was going to ask you, why would Cohen be adverse to them taking all that time off when things were going his way? Does the fact that, well, now you've let him off for 10 days and two of them got COVID, now we're starting fresh. Now it looks like this may be an adverse development for his client. Is he trying to connect all these dots?
He's trying. And, I thought it was interesting, too, that Cohen appeared to make the argument today to the court that, well, you're replacing jurors, but the jury's already hopelessly deadlocked and they're not going to move out of their respective positions. And Judge Almeida immediately called him down on that and said, no, what they didn't say they were hopelessly deadlocked. They said that they had not been able to reach a unanimous verdict. Not reaching a unanimous verdict is different than being hopelessly deadlocked. It just means that we haven't agreed yet. Doesn't mean we won't agree tomorrow or in 10 minutes or in 3 days. It just means that at this moment, we are not in agreement. Not that we are immovable out of our respective positions. We just haven't found a middle ground yet.
Right. What happens? There's only one more alternate left on the jury.
Mm-hmm.
What happens if 3 more jurors come down with an illness?
It would be a mistrial.
Automatically,
because I've got the comments going over here on my other screen, and then I see on here, first off, my apologies for being late. It's not Aaron's fault. I tend to just run about 10 minutes late everywhere I go, so don't hold that against him, please. But secondly, somebody said they were surprised that they could pull somebody in who wasn't there for the trial. They were. When they sat the jurors, they sat 12, and in a case of this nature, they're always going to seat one or more alternates, and in this case, they sat several. Those alternates, most of the time, don't know their alternates. Let's say they select 18 jurors. They have 12 plus 6 alternates. All 18 of those jurors hear every bit of testimony. They see all the exhibits. And then when it's time to retire to deliberate, the judge says, you 12 are my jury. You 6 are my alternates. These 12 are going to go deliberate. And if we need the alternates, I'll replace you at some point in time. The alternates have been there. And in fact, in most jurisdictions, the judge won't tell the alternates they're the alternates because they want everybody to think that they're going to be the starting 5, right? They want everybody to think you're going to be the 12. So they all give the same type of attention and focus on the case that they would if they were on the 12. In theory, if I'm an alternate, I may not pay as much attention. We want everybody to be as attentive and focused as we can. So you don't even know that you're an alternate until the jury actually retires to deliberate.
What sort of effect does it have on the proceedings to basically now telling them they're going to restart for a second time? This is the second time. I mean, they already had to seat one alternate. Technically, deliberations restarted at that time as well, yes?
Yeah, I think part of it would depend. If they have to seat an alternate, say, into the first day, 5-6 hours into deliberation, there's not a lot of progress that has been made yet at that point. They're still probably going, with the jury instructions and stuff, they're probably still reviewing jury instructions and looking at the evidence, probably haven't started to discuss a whole lot. So restarting it is only setting them back 4 or 5 hours. In this case, restarting it is setting back the deliberation 2.5 days. But it doesn't necessarily mean anything because these individuals may be able to come to a unanimous decision faster than the original makeup of the jury. That's something that's purely hypothetical. We have no way to prove or disprove that, but that's,
Is there any way, does the judge already know who the jury foreman is?
No.
So for all we know, the foreman could have just been replaced and we wouldn't even know it.
Theoretically, there's no way to know. Now, theoretically, she might know in the future. Most of the time when the jury sends out a note, they don't type it out. It's written on a post-it or a piece of notebook paper, signed and dated, and then handed to the judge. She may look and say there's different handwriting. She may look and say that there's a different signature on it, but I don't know that the attorneys would even know that. I don't think that the attorneys would be privileged to that. In my cases, when I've had a question come out of the jury room, the judge will say, here's the question that I've received, but we never go up and look at it. He or she's never let us look at the question or look at the handwriting or look at the signature. Uh, in Oklahoma courts, there's a form that comes as basically pre-printed lines with the signature block, so you write your question on it. Each jurisdiction does it differently. But I never knew until the jury returned with the verdict whether or not the foreperson was a man or woman or who it was. Now, I have my thoughts. I think it's going to be this person, or I definitely don't think it's going to be the guy on the end who slept the whole time or whatever, different things. But I've never seen it. I've never seen the actual note itself. The judge will say, here's the question, and here's what I'm proposing the response would be. I'll take argument from both parties, and then I'll make a ruling and instruct the jury.
Yeah. I actually have the breakdown of the jury by age, race, and gender. That's not something the media has discussed, but it's something anybody present in the courtroom is aware of. Is it kind of considered a poor form for the media to discuss things like that?
Not necessarily. So the media they cannot give names, and they can't give, in theory, they can't give such specific information as for this person to be identifiable outside of the courthouse. In a small county, I mean, I grew up in a town of 2,000 people. We had one stoplight, and at night it flashed red in all directions. Okay, so if you went to the district court in the county I grew up in, you give me a good enough description, I can tell you who it is. LA County is so big that I could give a super specific description, and that would match any 150,000 randomly selected Los Angelans anyway, or Los Angeles, whatever they call themselves.
Angelinos.
Angelinos, there it is. I read it the other day, but I wasn't sure how to say it. Angelinos.
Um, what was I just going to ask? Oh, I think it's astonishing more people have not come down with the illness. At least 3 people have tested positive since this trial started, and it's indoors. People aren't wearing masks. I'm just really surprised there hasn't been more contagion, and it's pretty concerning to know that if there's much more contagion, it could be an automatic mistrial. Although, do you imagine at this point a mistrial? Let me ask it another way. Is this development bad news for the defense?
I would think so, because the defense probably, so the attorneys will know, because I just talked about how the jurors aren't going to know if they're an alternate or a juror. The attorneys know. When I sat alternates, I knew who my 12 were and I know who my alternates were. And so I sort of have a feel of the body language of those 12, because I can't focus on everybody, so I'm going to focus on my 12. So, knowing sometimes the devil you know is better than the devil you don't. I know the 12 I had in the box, and I don't know necessarily, I don't have a real good feel for these alternates, just because I didn't have the ability to focus on the alternates like I did the full jury during the case itself and during the closing. So I would certainly, as a defense attorney, I'm certainly more concerned with my alternates than I am with my original 12. Without a doubt, it certainly gives me reason to be a little bit apprehensive. And I'll walk back a statement I made earlier. Something just occurred to you. Said, if more people were to test COVID positive, what would happen? I said a mistrial. That's the default position. However, if somebody made the right argument, theoretically they could convince the judge, we will suspend deliberations until this juror is asymptomatic and test negative, and then we can resume deliberations. That's possible. However, I know some people who are positive and never sick. I know some people who are negative and sick for weeks. And then unfortunately, there's some people who get it and they don't recover either completely or at all. And so it's a bit of a question. You could suspend jury for 3 or 4 days if a person was on the mend, but they're not going to suspend it indefinitely, because theoretically this juror may never get better. So I would think a mistrial is probably what would happen, although I could see it being a situation where the judge would say, "Hey, we're going to suspend him for a week to get this person to test negative and be asymptomatic. We'll reconvene in a week, and then we'll retire you to deliberate if everybody's still healthy."
Right. One of my sources in the courtroom who's been watching and studying the jurors very closely did feel that the jurors who were excused due to testing positive were jurors that were leaning towards acquittal. Do we know any of that for sure? No. But all we're doing in the meantime is speculating. That's literally our business until this jury finishes. And so, for what it's worth, there's a little bit of speculation that I received from someone who has been there and has been paying very close attention. So, the way I've been looking at it is, last Friday, it seemed like not only did the jury say they weren't able to come to a consensus, but there was visible frustration on the faces of the jurors as they would come and go. They were taking a lot of breaks. They were breaking early. It was strange. You sort of got a sense that something was not right. The notes that we're seeing today from the jury or about the jury have a much different tone. They seem to be working longer. They seem to be working harder. It's sort of, one might infer they're making better progress. Any
Yeah,
thoughts on that?
yeah. So I see it one of two ways. Either the jurors that they brought in are in agreement with the current position of the jury, or they appear to be making headway, but in reality, they're covering in several hours what they just spent 2.5 days on. Because we've only got to get up to speed 2 people. Originally, we had to get 12 people up to speed at their own pace. 10 people already know the status of where things are. Now we've just got to brief these other 2. So it could be one of two things. It's either there's a lot of progress being made because their positions, these 2 jurors' positions, may not be that far off from where the jury's current position is, the other 10 jurors are, or it could be that they're just trying to reconstruct the last 2.5 days for these people.
Yeah. Well, we're 3 hours ahead. It was funny because last week, the court kept ending relatively early, so we kept getting notes out relatively early. But if these jurors really do stick in there for long, full days, we may not have any idea what happens until after 7 p.m. What time does court get out at 4 p.m.? Is it standard nationwide?
No, it's done on a courthouse by courthouse basis. In Oklahoma, it's the courthouses are open to the public from 8 to 5. The most dockets run 8 to 4, meaning the last docket of the day the last matters of the day would be scheduled at 3 o'clock to be heard on a 1 hour docket. But will it go past 4 o'clock? Of course, 4:30, whatever. When I was there for trial, the jury's expected day was 8:30 to 5. They needed to
Hmm.
be in the courthouse at 8:30 to retire to deliberate at 9, and then they would stay there till 5. Now, on the last day, they were close at 5 and asked the judge for more time, and they were there for 3 or 4 more hours. We got out late, 7, 8, 9 o'clock, something like that. It's been several years, but it's very possible that that's the situation. And I don't know Judge Almeido's position within the courthouse, and what I mean by that is every courthouse has a presiding judge, generally elected by their peers, but a presiding judge. That presiding judge sets the courthouse hours, makes courtroom assignments. Most cases are automatically assigned by the computer to the next judge up, the next judge in the civil docket, next judge in the criminal docket, next judge in the probate docket, whatever. Um, and so it could be one of those that, the normal courthouse day is 8 to 4 or 8 to 4:30 out in LA County. And unless the jury says, 90 minutes and we're done at 4:30. And if they have to come back the next day for 45 minutes to make one final vote and sign the papers, we come back and we do it in the morning. What I can expect, though, what I will say is, even if the jury comes back with a verdict at 5 p.m., the judge will hear the verdict that day. I don't expect that the verdict would be in late and the judge would take a night and then hear the verdict in the morning. Logistically, there's a lot of things that have to happen. If it's a not guilty verdict, of course, Danny Masterson is free to go. If it is a guilty verdict, he will, I would presume, be remanded into the custody of the LA County Sheriff. He would be taken and booked and all the other logistical things that have to happen. And from the layperson standpoint, when the verdict comes in, good or bad, as soon as the verdict is read, The judge will, after the verdict is read, the judge accepts it and enters the verdict into the record. The judge will look up and say anything from either party. And most of the time it's no. And just like that, it's over. Turn out the lights, go home. I mean, it's a little bit strange. It's sort of like a song that doesn't have a smooth ending. You just hit the last chord and the music stops. Sort of the same thing. Anything from the state? No. Anything from the defense? Nothing right now. All right, we'll see you later. And we're done. It's sort of an odd stop to this thing that that the attorneys and the parties have been emotionally and financially invested in for, in this case, years, but often months or years.
God, it just seems like such an anxiety-inducing process with a massive adrenaline dump every time you hear that buzzer. That is exhausting just thinking about it.
It is, and I tell people that waiting on a jury verdict is sort of like waiting on a child. Waiting on a child to be born, right? Mama's in labor and she's laboring down for a day and a half, and you're exhausted and she's exhausted, and I don't care what the outcome is, just give me an outcome. So and I've got children of my own, but I sort of give that example. It's a lot like waiting on a child because you are invested in the outcome of this case. And so when you win, there's a high. When you lose, there's a low. But whether you win or lose, there's this level of absolute exhaustion. And if you've seen the verdicts like on Law and Crime Network or Court TV, something like that, when the verdict comes in and it's read and the courthouse sort of calms down, you look over and the attorneys are just sort of slumped in their chairs because that high is worn off and now we're just exhausted.
Yeah. Well, incredible. I don't know what your availability is in the evenings, but if we do get a late verdict and you're available to jump on, we can make that happen. So,
of course, yeah, and I'm watching as soon as I hear something. Like I said, if all I need is about 20 minutes notice, and I may end up, if I'm coming from the gym, I'll look like I just got done running in the rain. But hey, we can, as long as they're willing to forgive me, we'll work around that. And for those out there, make sure you subscribe to the channel. Make sure you order your Mike Rinder bobblehead doll. Support the Aftermath Foundation.
Here we go. Right here. Let me throw it up here. Mike Rinder bobbleheads. Go to the SP shop. Get 1, get 2, get 3. Guaranteed to repel any Scientologists secretly surveilling you. They melt at the sight of a Mike Rinder bobblehead. All proceeds from the SP shop go to support the Aftermath Foundation. The Aftermath Foundation helps people who are escaping from Scientology. And Mike Rinder is on the board of the Aftermath Foundation, as am I. So, all right, Zach, anything else before we end it for today?
Yeah, if you'll jump over to your comments, Elaine has a super chat. Thanks to her, asking when Danny's found guilty, will I assume the sheriff, take him straight to jail and strip search him against his will? Presuming that he is remanded into custody, yes, he will be taken to the LA County, probably the Men's Central Jail, and he will be strip searched. But what I will tell you is he's not going to have anything on his person right now anyway, other than a wallet, maybe some car keys, because he's gone through security to get into the courthouse. And when he's remanded, I mean, the deputy sheriff in his suit and tie, they will place him in handcuffs, take him down to the Men's Central Jail, and process him. So he will be strip searched against his will. Although who knows, he might be willing. I don't know. That's not for me to say. I don't sit in judgment. But yes, presuming he's not left out on bond, I would certainly argue that he's a flight risk given his access to assets and resources. He would be remanded into custody and taken to the LA County Jail for processing, and will be held until sentencing.
So that reminded me of a question. When I was at the federal courthouse here in Tampa last week for a hearing in the Baxter and Paris versus David Miscavige et al. Case, there's no computers, there's no phones allowed in the courthouse. They even turned council member Mark Bunker away to take off his Apple Watch and return it to his car. And we're like, Jesus, this is hardcore. And then we're there in the courtroom, and in the bench, there's almost like pews in the seated rows ahead of us. There's a girl there just typing away on her cell phone. And I pointed it out to one of the journalists. I'm like, what's going on here? And she said there's actually different rules for lawyers. Is that true?
Yeah. So what I was digging for, this is my technology access card for the federal court, Western District of Oklahoma. As an attorney, I had to sign an oath that says I won't use it against the rules. I won't allow it to be distracting. literally had to put my bar license on the line and sign that oath, and take the oath. And when I go through security, I have to show that, and they let me keep it, but I'm still subject to the reasonable use. I can use it for docketing, but I generally, sitting there, can't use it for text messaging. But I can use it for docketing. I can, ask for leave. Judge, may I step out in the hall and call my clerk or whatever, something along those lines. And so, sort of depends case by case. But
Got it. Zach, remind everybody what your answer was to this question last time.
sure, yeah. So I'm in the process. I'm working with a good friend of mine to co-host a YouTube channel, sort of a video podcast style format. We're hoping to have that stood up, to stand that up shortly after the first of the year. So stay tuned. I see lots of love from you guys out there asking for the YouTube channel. We're working on that logistically on how we're going to do that. And right now I'm just speaking from my office. So we're trying to make sure that we have the floor space to make sure we get a good space set up so we can bring you the best quality content that we can.
I'll tell you what, whenever you set up your channel, I'm going to have to send you a life-size cutout of David Miscavige just so that people can see how big you are standing next to David.
Very good.
All right, let's see. There's one here.
And I see Chelsea's question there. Could they sequester the jury to prevent infection? They absolutely could. I don't know if that request has been made, but it's certainly an option. But the judge can really do anything he or she wants to. And there's a Latin term for that called sua sponte. It means on the court's own, on his or her own. Generally, courts don't abuse that. They just sit back and say, if you want something, you ask, and then I will make a ruling on it. So the judge could order it, but she hasn't ordered anything sua sponte. She's, other than this jury thing, and somebody was going to have to ask for it anyway. The judge could order that they be sequestered, but generally one of the attorneys would ask. At this point, though, there's some issues with the sequestration process. Trying to book a hotel room in downtown LA for that many people, you have to have 12 hotel rooms. You've got to have security for those 12 people. So you've got to find a way to have deputy sheriffs posted outside the floor of the hotel. You have to, when I say control access to those individuals, they would eat together, they would dine together probably in the hotel, but they couldn't discuss the case unless they were in the courthouse in the deliberation period. It's also rather inconvenient to ask these people to go home and pack a bag. A lot of these folks, right, if they're like me, they're washing the laundry at night and putting it on in the morning, right? So it could very well be a situation like that. So there are a lot of logistics. Is sequestration possible? Absolutely. But generally, that's something that is decided very early on in the process, long before the jury gets the case, to the point that I think it was in the, was it the Ahmaud Arbery case in Georgia, or the one of the cases up in Minnesota, the judge even told the jury during jury selection, we may have to sequester you. Are you prepared to pack a bag and stay long-term for as long as it takes to reach a verdict in a hotel? And that was part of the jury selection process. So is sequestration possible? Absolutely, it's possible. I don't know that it's the best option in this case at this point, but anything's an option and the judge will do whatever she feels necessary to preserve the integrity of the jury and do everything she can to allow the jury to reach a verdict before she declares a mistrial.
Are jurors allowed to give interviews after the trial is over?
Absolutely. They are not required to. It is completely discretionary, and the judge will instruct them as such. Your jury service is terminated. You are free to speak to whomever you wish about any matter, about this case, in any manner in which you choose to speak to them. But you do not have to speak to somebody. If they ask you if you want to talk to them and you say no, that's good enough. You don't need to give a reason. If they start to harass you or bother you or continue to ask for an interview or to ask to meet, and they're not accepting no as an answer, you bring it to my attention or the attention of my staff, and I will take care of it, because it is completely at your discretion whether you talk or not.
That's going to be really interesting to see if we get to hear some of the behind the scenes stuff.
And they are theoretically, unless, and I'm not a lawyer in California, unless California law precludes it, it's like any other aspect of the media. They may say no, and then if I offer a big enough check, they may say yes if I pay them for an interview. There's nothing, unless California law precludes that, that's possible as well. Listen, I just spent 7 weeks away from my family, 6 weeks away from my family. I want to go home. We'll give you $10,000 to do an exclusive. Where you want to meet? right? I mean, money talks.
Yeah. Fascinating. Well, thank you so much, Zach. It's been incredibly helpful. And stay tuned, guys. I guarantee we're going to have more to talk about tomorrow. Have a wonderful evening.